Hey everybody, it's Kristen McIntosh, the happy lawyer here at Schweitzer and Associates, and welcome to this month's webinar, Oh, the Places You Will Go, Estate Planning for the Young Adults. This is part of our monthly webinar series, which we do host on the last Wednesday of every month. This month, though, our focus is on all of you young adults out there who have recently turned 18 or are already 18 years of age or older, as well as the parents of those young adults. So today I'm going to talk to you about, what estate planning documents you should have and why you need to have these estate planning documents in place. So stay tuned, everybody. But first, a little bit about me. I am happy. I am Kristen McIntosh, the happy lawyer here at Schweitzer and Associates. And yes, I am an attorney and I am happy. I know that defies all logic, but I am both happy and an attorney because I absolutely love what I do, which is working with my clients, developing relationships with them so that I can create unique personalized estate plans for them.
Happy birthday!
Happy birthday to all of you out there who have recently turned 18. It's an exciting year. I know. Now you are no longer a child. You are now an adult. Yay! For you parents out there, this may or may not be a good thing. However, when you turn 18, it is a major milestone in your life. Now, why am I saying it's a major milestone? What's so great about turning 18? Well, you see, when you're 18, you're getting ready to embark on some great new adventures. Perhaps you're graduating from high school. Maybe you are preparing to head off to college for the first time. Or you might be starting a new job, or your first real job in the adult world. You might be moving away from home. All of these are exciting opportunities for you, and they're all new beginnings because you are starting a new phase in adulthood now. However, with the becoming an adult and starting that new phase of your life, you are going to have some changes in the legal decisions and activities that used to be controlled by your parents out there. You parents know that when your young adult child was a wee little child, you got to control everything that happened in their life. You determined what doctors they went to. You got to decide where they lived. You picked the schools that they attended. You even got to decide such things as how their finances should be handled. But now your child is now a young adult, and everything has now changed. Because see, your young child is no longer a baby. He or she is now a grown adult. He is considered an adult in the eyes of the law. And this means that now your young adult child, or you as the young adult child, have the right to choose where you're going to live, whether or not you're going to go on for further education, who can make decisions for you, who can access your personal records, who can, decide where you're going to live. These are all important decisions that used to be made by your parent or legal guardian, but now you get to make those decisions. So with the passing of one day, the day after your child turned 18, your child went from being a young child to an adult in the eyes of the law. And, when they were a child, your young adult child, or you as the young adult, were used to others making decisions for you. You got to make maybe some small decisions about what you might like to eat for dinner, but you pretty much didn't have a say on major life decisions such as where you were going to live and whether or not you were going to move. And, even though you are now an adult and can make decisions for yourself, there may be times when you as a young adult will still need assistance in navigating your newfound freedom. You might need, a parent's help to make financial or medical decisions for you, especially if you're not able to do so. But in order for your parent to make those decisions for you, you have to take affirmative steps to make that happen by executing certain legal estate planning documents that we're going to cover in this webinar in a few minutes.
Oh, my little man is all grown up.
Yeah.
Objection.
Okay, I hear you parents out there. You are going, wait a second. What do you mean I don't get to make decisions now that my child is 18? Let's just rein this in, lady. You're thinking you're just crazy here. You're going, I'm the parent. This is my child. Of course I can make decisions for him. After all, I'm still paying their health insurance. I'm paying for their college education. I'm the one who raised the child. Well, unfortunately, I do hear you and I do sympathize with you. But unfortunately, the law doesn't feel the same way. They don't have, the human feelings. Sorry. The law's pretty much black and white. And under the eyes of the law, when your child turned 18, he or she became an adult and has the responsibility and the right to make decisions for him or herself. But let's take a step back and, think about how this might affect your child if there are no estate planning documents in place. So we're going to imagine that your adult child is injured in an accident. He's taken to the hospital and for what, is unconscious, so he can't make any decisions for himself. Perhaps, your young adult child is in a coma. And you show up at the hospital and you start telling the doctors what you want done for your child. Well, unfortunately, the law says your child's 18 and is a legal adult now. The law and the doctors are not going to care that you're paying for your child's health insurance, and they're not going to care that you might be the right person to make those decisions. It doesn't matter that everyone knows, hey, if your child would want you to make medical decisions for himself now that he's unable to do so, but unfortunately, without certain estate planning documents in place, you most likely will not be able to make those decisions. Now, I don't know about you. As a parent, I would not want to be in that position. I'm already going to be upset enough that my child is in the hospital. And now I'm being told that I can't make decisions. I can't do anything for my child. Okay, that's not a good situation to be in. So we're going to talk about how we can avoid being in that situation.
Ready? 1, 2, 3, 4.
So we're going to talk about the important documents you need to consider. And there are 4 major documents. The first is the financial power of attorney. This next is the healthcare power of attorney, along with the living will. And then we have our HIPAA form and our FERPA form. And as your young adult children transition into this new phase of life, into becoming adults, these are the important documents that they need to have in place. So let's talk about them one at a time on here. The first document we need to talk about is the power of attorney, otherwise known as a financial power of attorney or a durable financial power of attorney. Okay, what is this document? This essentially is a document where your child, who would execute this document, sign the document, and would appoint a person of their choosing to make financial decisions on their behalf. Now, when your child executes that document, under the law, he is referred to as the principal. You, as the person who is being authorized to make these decisions for your child, are known as the agent or the attorney in fact. And once you have been appointed that agent or attorney in fact, you now can make medical decisions, or make financial decisions rather, on behalf of your child if he or she is unable to do so. Let's say your child is takes a trip abroad and travels somewhere where there's no ATMs, no banks, and now your child needs money. Ugh. Well, if he has executed a financial power of attorney, then you as the parent can wire money from your child's account to your child wherever he or she is so that they can continue on their travels and hopefully make it back home to you safely. Or you might need to write out some checks for your child. Let's say your child is in that accident and he or she was renting an apartment. Well, if you were the attorney of fact or the agent for your child, you could write checks out of your child's bank account to pay the rental payments. Otherwise, you're going to have to pay those out of your pocket, and hopefully your child will reimburse you for those payments on there. So let's talk about some of the benefits of having a financial power of attorney in place. As we discussed, by executing a financial power of attorney, your child can authorize an additional person to help with managing their financial affairs. Now, of course, your child, even though you've executed that power of attorney, you still are going to manage your financial power of attorneys. The agent only comes into play when, for whatever reason, you're unable to manage those affairs. You don't have access to your bank account, or worst case scenario, you have that traumatic brain injury from that accident that we talked about earlier. This document can be very helpful when your child is going away to college or when they're traveling away from home, as we pointed out earlier in the earlier example of the child, traveling abroad and not being able, or needing funds and not being able to access any bank accounts. The document is also helpful to you as the parent if your child is still receiving financial assistance from you, because you can go into your child's account, you can deposit money, you can withdraw money from your child's account, obviously with your child's permission. You can't just start embezzling funds. You have to act in good faith. But of course, it's your child. You're not going to steal from your child, so don't worry. And if you do think your parents are going to steal from you, young adults out there, you probably don't want to make them or any other person that you have doubts about as your agent. You want to appoint a trustworthy person. Okay? So the next document
We need to talk about a power of attorney.
is we need to talk about the healthcare power of attorney. Now, the healthcare power of attorney is similar to the financial power of attorney. However, like the financial power of attorney, with the healthcare power of attorney only lets your agent make medical decisions on your behalf. Your agent can speak to your medical doctors, they can authorize treatments, they can get you transported to and from facilities. They can essentially do everything that you could do with your physical and mental health care that you could have done had you been able to do so. So when does this healthcare power of attorney go into effect? It only goes into effect when the attending physician determines that you, as the young adult, are unable to communicate with him or her. You might just be unconscious, or perhaps you have a concussion and you're just not understanding what the doctor is saying. It could be, worst case scenario, that you have that traumatic brain injury or you've developed some form of dementia or Alzheimer's where you really don't know how to communicate or understand what the doctor is saying. So in that case, your agent would step forward and would be able to, again, talk to the doctors, make medical authorizations to him or her as to what should be done. And if it's a case of, you just had that concussion or you were in a coma, once you resume consciousness and are able to communicate with your doctors, then your agent's authority ceases. You then resume making your own medical decisions on your behalf. Okay, so it's not I appoint this person and now I can't make any medical decisions ever for my behalf on here. It's only a just-in-case document. If you're not able to act on your behalf, then the agent can step in. And along with the healthcare power of attorney is another document called the living will, sometimes called an advance directive. And the advance directive goes one step further, as it essentially gives your healthcare power of attorney some guidance as to whether or not you would want life-saving measures to be taken on your behalf. And if so, under what circumstances? And also, if you don't want any life-saving measures, under what circumstances would that be? Now, when I say life-saving measures, what am I talking about? I am talking about when you are, if your heart stops beating, would you want to be resuscitated? If your lungs aren't going to be able to breathe on their own, would you want to be hooked up to life support? And if so, how long do you want to be on life support? When we're talking about situations where these life-saving measures may need, your agent may need guidance as to whether or not you would want those done for you, we're talking about situations such as you have a terminal illness and you've reached the point where there's no further treatment or anything can be done for you. We're also talking about, being in a coma that the doctors have determined you're never going to come out of that coma. So you could be in that coma for, 25 years. So in that state, if you were in that state, would you want life-saving measures to be taken? These are important things for your healthcare agent to know. And as we age and circumstances change, we may change our minds. So it's very important that you and your agent stay in contact and that you, occasionally have that dialogue as to what you may or may not want done for your health. So there are several benefits to having that healthcare power of attorney and advance directive in place. It allows a hospital to quickly determine who can speak up for you if you're not able to do so. You were wheeled into the emergency room, you're unconscious. Yes, the doctors are going to do what's necessary. They're not just going to let you linger there till they find somebody to speak on your behalf. But if there's, they get you situated and they get you where you're stabilized, they may need to know what options that you would like done as far as the various medical treatments that you could undergo. And that's where your agent could step in and talk to the doctors and advise them, so the doctors will proceed with the medical treatment that you would have wanted had you been able to speak for yourself. The healthcare power of attorney also potentially saves a lot of money, because if you do not have that healthcare power of attorney in place and you're unable to speak for you, then your parent or you parents are going to have to hire an attorney. You're going to have to file for a guardianship, and you're going to have to pay court fees, and you're going to have to be at the mercy of the court to determine whether or not you or some other person should be able to speak up for your child and make those decisions. Meanwhile, your child is at the mercy of the attending physicians, who will use their best judgment in guessing what your child would like to have done, and as well as balancing it with what needs to be done. Not a good situation to be in, either as the child or as the parent. So you definitely want to think about getting that healthcare power of attorney and living will in place sooner as opposed to later.
I want a hippopotamus for Christmas.
Okay, we're getting to the HIPAA document. And remember, that's HIPAA, not hippo. Everybody, big difference. Hippo's the animal. HIPAA stands for the Health Insurance Portability and Accountability Act. This was an act that was passed by Congress a few years ago. This act protects private patient information. It limits the disclosure of that information to anyone other than you, the patient, or your doctor, unless you have authorized in writing that it's okay for your medical information to be released to a third party. for young adults out there, that third party could be your parents. It could be an attorney if you were involved in some type of personal injury accident or well, you'll just stick with personal injury accident for this scenario. It could be maybe you have a trust set up and the trustee needs information to make a determination as to your capacity. Anyway, there's a lot of reasons why someone may need access to your private health information. And yes, while you're alive, you can make that authorization, and as long as you're able to speak up and sign that document. But what happens if, again, you're in that accident, you're in the hospital, and you're unconscious? Well, if you don't have that that HIPAA document previously executed, then most likely the doctors and nurses are not going to be able to talk about your medical condition with your loved ones on here. So we're getting into the benefits of why you need to have this HIPAA document in place. Now, keep in mind, if you go to the doctor on a regular basis, you most likely are presented with a HIPAA form every time you go in. This is that form that you sign where they ask you who they should contact in case of an emergency, and they have you check whether it's okay for them to leave a voicemail or speak with another person about your medical treatment if they can't reach you. That document is the HIPAA form, but not everybody goes to the doctor. And when we switch to new doctors, we go off to college, we may or may not execute one at the health campus, the medical center at the college campus. So it's important to go ahead and make sure you have executed a HIPAA where you name a responsible party, a person whom you trust, most likely your parents, should be listed on that document so that they can access your medical records if they need to. Now, this does not mean that your person that you put on the form is going to constantly keep calling the doctor to say, hey, I want to see my child's medical records. Okay, that's not the purpose of it. The purpose of it is that they can access those records if they absolutely need to do so, such as in an emergency situation. So if you don't have that authorization already executed, as we discussed, your parents aren't going to be able to access your medical information. And by being able to access your medical records, your parents are going to be able to make the appropriate medical decisions for you because they're going to have all of the necessary information before them. And hopefully you've already had a prior conversation with your parents about what you would like to have done. So the final document
Marsha!
that we're going to get to is FERPA. FERPA, it's a really fun word to say. I like saying FERPA. Now, some of you are scratching your heads out there and you're like, FERPA? Oh, what? What did she say? Well, FERPA stands for the Family Educational Rights and Privacy Act. Now, this law was put in place to protect your child's educational records. Now, when you and I went to college, our parents could access our educational records. They could just call up the college and say, hey, I need to see my, child's grades or GPA test scores, and the college would release them. And some of the colleges actually sent your educational records directly to your house, and your parents would open the mail and be like, oh, I see that you got a, 3.5 GPA this semester, or, oh, you got like a 1.9. What's going on here? Now, FERPA changed all that. So unless your child has previously executed a FERPA document, your child's college or university is not going to release those records to you, the parent. FERPA does, again, just like the healthcare power of attorney and HIPAA, FERPA also does not care that you are paying for your child's tuition. They don't care that you are supporting your child, you're paying your child's room and board, you're buying your child's books. FERPA could care less because FERPA is a law, and remember, laws don't have feelings, unlike people. So when your child, if you want to be able to access your child's educational records with your child's, and you're going to need your child's permission, and your child will need to execute that FERPA. Now, when your child executes the FERPA, his grades, class schedules, and more can be released to you. Otherwise, they are protected and they cannot be released to anybody unless your child consents. Now, a lot of universities talk about the FERPA document in the college orientation proceedings. So most of you who already have children in college or have been attending these orientation proceedings are probably aware of the FERPA. And I did include it in this presentation just in case you did not know about it, because it does go hand in hand with the other estate planning documents that we mentioned. Unfortunately, most colleges do not talk about the other estate planning documents, the healthcare power of attorney, the financial power of attorney, the living will, and the HIPAA, which is why I covered those. So all of these documents I would encourage you as a young adult, or you as the parent of a young adult, to get these documents executed. Because remember, becoming an adult is a major milestone. And when you're an adult, you take on adult responsibilities, and you need to start looking out after yourself now. You don't rely, or you're not relying on your parents to make the important decisions. And you're like, now, I'm not saying you shouldn't be consulting with your parents and asking their opinion on there, but you get to make your own decisions, and you need to be properly equipped to make those decisions. So I would encourage all of you parents out there that, when your child turns 18, you should have a heart-to-heart chat with your child about, the responsibilities of being an adult. Now, I probably wouldn't do it on your child's actual birthday. You may want to wait a few weeks to let the child ease into, hey, I'm 18, yay, before hitting them with the, well, you're an adult now, and now you have responsibilities talk. But when you do sit down and start talking to them about, paying bills and making medical decisions for themselves and deciding where to live, what college to choose, you may also want to bring up the topic of getting their estate planning documents in place, and pointing out that those documents need to be in place to protect them, in case something happens. Because as I've always said, life happens. We don't plan on getting into an accident. We hope we're never going to get into an accident, but we could get into an accident. So we need to be prepared. Always be prepared. And some people have the thought that if they have things already in place and are prepared, then it, alleviates the possibility of events from happening. Don't necessarily go along with that train of thought, but there are people out there who do think that. Anyway, the point is, we need to get these documents done. And for you parents out there, I would encourage you to make sure you have your estate planning documents in place, because it's a little hard to encourage your children to get their estate planning documents executed if you, the parent, don't have yours. So here's a great idea. If you don't have your estate planning documents in place, and your adult child doesn't have the estate planning documents in place, maybe y'all could arrange a family trip to your local estate planning attorney's office and get those documents executed. Okay, maybe not the most fun activity in place, but after you have that meeting with your estate planning attorney, then y'all can go out and do something more fun. And trust me, you will feel so much better once you have those documents in place. So just do it. Get her done.
That's all, folks.
So everybody, I thank you so much for attending this webinar on estate planning for the young adult. I hope that I gave you some insight on what documents that you need and why you need those documents. And if you have any other questions that I didn't cover, or you want to explore more topics in depth, you can always reach out to me, or you can shoot me a question in the comments, which I will answer. My information is up here for you if you want to reach out, either you need more information or you want to set up an initial consultation to start the estate planning process. My email is listed, as well as my direct dial number, which is 919-535-9131. So please don't hesitate. I always welcome questions and love to help people, get their estate planning affairs in order. Also, a little plug here, we are on social media, where each week we post blogs, weekly tips and videos, as well as sometimes some infographics and other documents that you can download and keep. You don't want to miss out on those. So you can follow us and like us on Facebook, Instagram, LinkedIn, and YouTube. You can look for Schweitzer and Associates on all of those. On YouTube, it is the Happy Lawyer NC that's the handle. That's how you find us on that. I do have the links listed up there. So take a moment to copy them down. And again, otherwise just search Schweitzer and Associates or the Happy Lawyer NC, and you will hopefully find us. And I hope that when you do find us, that you will follow us, because we do love our followers on here. I want to again thank you all so much for your time and attention and participating in this webinar. And I am now going to take some questions from the audience. So until next time, everybody, stay happy.